My name is Mara Eldon. I'm 34 years old. 3 weeks ago, I opened a certified letter from a law firm I'd never heard of and read one sentence that told me my parents were selling a farm they did not legally own. The letter was 3 paragraphs long. It used the phrase, "as the rightful owners of the subject property." It asked me, as a potentially interested party of record, to sign an attached quit-claim deed by the 14th of the month. I didn't call my mother. I didn't call my father. I set the letter down on my kitchen counter next to a cold cup of coffee, and I counted. 8 seconds of silence. Then I opened the top drawer of my filing cabinet and pulled out a sealed manila envelope my grandfather had handed me on the porch of that farm 12 years ago, the week before he died, and I laid it on the counter next to their letter. That envelope was supposed to be my insurance policy. My parents thought it was a greeting card. I work as an estate planning paralegal. I've drafted, filed, and administered trust for 11 years. I know what a recorded memorandum of trust looks like. I know what an irrevocable clause does to a family farm. I know exactly what it means when 3 paragraphs of lawyer language leave out one word, and the word my parents' attorney left out was trustee. By 9 a.m. the next morning, I had printed a certified copy of a document my parents did not know existed. By noon, I had called their attorney back and asked him politely to schedule a signing meeting. I offered to bring the paperwork myself. Before I tell you what happened in that conference room, please take a moment to like and subscribe to Broken Relations, but only if family stories like this one hit something for you. Drop your city and local time in the comments. I love knowing where you're listening from. Now let me take you back to the morning the letter arrived, and then further back than that, to the porch where a dying man handed me an envelope and told me not to open it until the day I finally had to. It's a Tuesday in March. I remember that because Tuesdays are my long day at the firm. I run the weekly trust administration calendar, which means I spend 4 hours going through every active trust file and checking distribution dates, tax filings, scheduled disbursements, and any flagged correspondence. I'd been in at 6:30 that morning. I'd had 2 coffees. I'd walked home at 5:45 carrying a grocery bag and my mail in the same hand. And I dropped everything on the counter and started slicing a lemon for a glass of water before I even looked at what I was holding. The certified letter had a green tag on it. Return receipt requested. My first thought was that it was about my renter's insurance, which had lapsed the previous month because I'd changed banks. I slid a knife under the flap and cut it open, standing up at the counter. The letterhead said Bram Hollis, attorney at law, with a Liberty Street address in the town I grew up in, a town I had not driven through in 5 years and had no plans to drive through again. I read the letter twice. The first time, I read it the way a person reads a letter, as a message from one human being to another. The second time, I read it the way I read documents at work, checking the party names, the defined terms, the statute references, the signature block, and the attached exhibits. It was on the second read that I found the word they left out. The letter referred to my parents as the rightful owners of the subject property 4 separate times. It did not use the word trustee. It did not reference a trust instrument. It did not reference a recorded memorandum. It did not list me as a beneficiary, only as a potentially interested party of record, which is the phrase attorneys use for people whose names appear somewhere in a chain of title, but whose actual interest they have not bothered to verify. The attached quitclaim deed would, if I signed it, transfer any interest I might claim in the 240-acre Eldon family farm Grandpa Howard's farm, my grandmother Wren's farm, the farm I spent every summer of my childhood on, back to my parents as individuals for consideration of $10. I didn't sign it. I didn't call my mother. I didn't call my father. I set the knife down on the cutting board next to the lemon, washed my hands, and walked to the filing cabinet in my second bedroom. The third drawer down contained 6 hanging folders, each labeled in my own handwriting. The last folder was labeled Eldon, Howard. I pulled out a sealed manila envelope that had lived in that drawer for 12 years. The glue was yellow. The seal was unbroken. On the front, in my grandfather's handwriting, it said, "For Mara, when you need it, not before." I carried the envelope back to the kitchen. I set it on the counter next to the letter. I sat on the kitchen stool and I looked at both pieces of paper side by side for a long time. Something in my chest went still. I should tell you what I do for a living because it matters. I'm an estate planning paralegal at a firm in a city 300 miles from where I grew up. My title is technically senior paralegal, trust administration, and the firm has 17 attorneys and a dedicated fiduciary accounting department. I've been there for 8 years. Before that, I was a paralegal at 2 smaller firms, one in my home state, one in the state I fled to. And before that, I was a pre-law student who didn't go to law school because I ran out of money the semester my parents told me they wouldn't co-sign a loan for the daughter who had always been stubborn. I did not go to law school. I went to community college at night, finished my paralegal certificate, and got hired by the first firm that would take me. I've spent 11 years doing the thing most people don't understand about estate planning, which is that the drafting is only about 20% of the job. The other 80% is the administration, the filings, the notifications, the beneficiary correspondence, the annual accountings, the sub-trust fundings, the deed transfers, the recorded memoranda, the Medicaid look-back analysis, the coordination with the title company when real property is held in trust. I can draft a revocable living trust in my sleep. I can spot a pour-over will mismatch in 30 seconds. I know exactly which clauses a testator can amend in an irrevocable trust and which clauses are locked for life. This matters because my parents do not know what I do. They think I'm a receptionist. They've always thought I'm a receptionist. The last time my mother called me, which was 4 years and 7 months ago, on my 30th birthday, she asked if I still answered phones at that law place. I said yes. I said yes because by that point, I had already figured out that the more they underestimated me, the safer I was. My father worked as a residential real estate broker for 31 years. My mother worked as his unpaid office manager for 28 of those. Between them, they have moved more houses through closings than most people see in a lifetime. They understand contracts. They understand deeds. They understand earnest money and title insurance. They do not understand trusts. Specifically, they do not understand irrevocable trusts with no contest clauses, corporate co-trustees, recorded memoranda of trust, and pour-over wills that reference the trust by name. They've never had to learn that part of the business because residential transactions almost never involve trust-held property. And when they do, the trustee and the title company handle it, and brokers like my father just sign off on the standard forms. My father thinks he knows everything about paper. My father has spent 31 years selling houses without ever reading a single trust instrument cover to cover. I know this because I've sat at a family dinner and listened to him describe a trust as just a will with extra steps. So when I opened that letter on a Tuesday in March and read the phrase, rightful owners of the subject property, I understood something my parents still did not understand. They had no idea what Grandpa Howard had done in the last 3 months of his life. Here is what you need to know about my family. My father, Dalton Eldon, is 68. My mother, Linnea Eldon, is 66. My brother, Reader Eldon, is 36, 2 years older than me. Reuter was the son they wanted. I was the daughter they got. My parents never said that out loud. They didn't have to. Reuter got the college fund. Reuter got the down payment on his first house. Reuter got the loan they said they couldn't afford for me. 7 months after, they told me I'd have to figure out school on my own. Reuter got my grandfather's truck. Reuter got his grandmother's wedding ring, the one she told me when I was 9 years old that she wanted me to have because Reuter needed it for his girlfriend. Reuter got 3 separate rounds of emergency money from our parents between the ages of 24 and 30, totaling, I later calculated, somewhere in the neighborhood of $180,000. Reuter did not get the farm. Nobody did. That's the part my parents never understood. Grandpa Howard was my father's father. He was a quiet man, a careful man, a man who ran 240 acres of corn and soybeans and a small cattle operation for 47 years, and read the paper at the kitchen table every morning with his coffee. His wife, my grandmother Wren, died when I was 11. After that, I spent every summer on the farm, not because my parents loved me more during those months, because my parents wanted a free babysitter who lived 2 states away and would keep me out of their hair while they focused on Ryder's baseball travel team. I learned how to run a tractor when I was 14. I learned how to read a cattle tag when I was 15. I learned how to help with the books when I was 16, which is to say, I learned how to reconcile a checkbook, how to file receipts, how to call the ag supply store and order what we needed, and how to listen to a man who had spent a lifetime on the same piece of land talk about what he thought the land was for. Grandpa thought the land was for family. He also thought the land was for the person who loved it. He said those 2 things a lot, especially in the last year of his life when he knew he was dying. He said them in front of me. He did not say them in front of my father. I want to give you 3 specific examples because this is where the story starts to press against the paper. First example. I'm 8 years old. It's my birthday. My mother has baked a sheet cake and my father has set up balloons in the backyard, and 6 of my classmates are coming over at 2 o'clock. At 1:30, Reuter, who is 10, trips and scrapes his knee on the driveway. Not badly, not bloody, just scraped. My mother puts him on the couch with an ice pack, and at 2 o'clock, when my friends arrive, she tells them, "We're going to have to reschedule. Reuter's hurt." She cancels the party. She does not reschedule it. When I cry, she tells me I'm being dramatic. I don't remember the cake. I remember my father watching Reuter play video games with the ice pack on the couch at 3 o'clock, fully recovered. Second example. I'm 22. I've just finished my 2nd year of college. I have a 3.8 GPA and a part-time job at a campus legal aid office. My father calls me on a Sunday in April and asks me to come home for dinner. At the dinner, my mother tells me, with a photocopied document on the table, that my grandfather has recently been diagnosed with congestive heart failure and that the family needs to consolidate the farm assets to protect them from Medicaid. They tell me that as the granddaughter, I have a 1/8 interest in the farm, on paper, and they need me to sign a quitclaim deed transferring that interest to my parents so the lawyers can do their thing. I asked to see the trust documents. My father says, "There's no trust, Mara. It's just a standard family setup." My mother says, "Don't make this harder than it needs to be." My father slides the quitclaim deed across the table toward me and says, "Your brother already signed his." I don't sign. I say I want to talk to Grandpa first. My mother tells me Grandpa isn't up for conversations right now. My father says if I don't sign, I'm not acting like a member of this family. Third example. I'm 22 and 6 months. It's Thanksgiving morning. I've driven home for the holiday because Grandpa asked me to come see him. My father meets me on the porch of my parents' house and tells me I'm not welcome inside unless I've brought the signed paperwork. I say I don't have it. He closes the door. I stand on the porch for 11 minutes in 20-degree weather before a sheriff's deputy pulls up to the curb. My father has called the non-emergency line and reported that his estranged adult daughter is refusing to leave the property. The deputy is polite. He is embarrassed. He asks me to leave. I leave. I drive 4 hours to Grandpa Howard's farm in the dark with no heat in my car because the vent is broken, and I cry for 45 minutes in the driveway before I go inside. Grandpa is at the kitchen table. He is 84 years old. He is drinking black coffee. He looks up at me and he says, "They did it, didn't they?" I nod. He says, "Come here, sit down. I need to tell you something." Grandpa told me that Thanksgiving that he had not been diagnosed with congestive heart failure. He had been diagnosed with stage 2 prostate cancer, which his doctor had told him was highly treatable for a man his age. He told me my parents had asked his doctor, a man they'd known for 20 years, to write a letter stating that Grandpa's condition was serious and declining. The doctor had refused. My parents had then told me, and apparently also told my brother, that Grandpa was dying and that the farm needed to be consolidated. Grandpa had found out about this a week before I did, from a conversation he'd overheard my father having on the phone in the barn. Grandpa had not been involved in any conversation about consolidating the farm. Grandpa had not signed any document authorizing the transfer of any interest in the farm. Grandpa had instead, that same week, called his own attorney, a woman named Ruth Kirkland, who had written his first will in 1978, and asked her to come out to the farm. She had. They had talked for 3 hours, and then, over the course of the next 6 weeks, Grandpa and Ruth had done something my parents did not know about and would not know about for another 12 years. Grandpa sat across from me at the kitchen table that Thanksgiving, and he said, "I need you to do me a favor. I need you to take this envelope, and I need you to put it somewhere safe. And I need you to not open it until the day you have to. Do you understand me?" I said I didn't understand. He said, "You will. You're the one who loves this place. I always knew that." He slid the envelope across the table. It was sealed. On the front, in his handwriting, it said, "For Mara. When you need it, not before." I took it. I put it in my backpack. I hugged him. He said, "Don't make a scene. Don't argue with them. Just live your life. And when the day comes, you'll know what this is." He died 8 weeks later. Prostate cancer, treatable, untreated by the time the family's attention went elsewhere. That's what his death certificate says. I was at the funeral. My father gave the eulogy. He called Grandpa a great steward of family resources. He did not mention my grandmother. He did not mention me. The envelope sat in my filing cabinet for 12 years. I did not open it. I knew what was in it. I had a guess. I've been working in estate planning for 8 of those 12 years, and I'd seen enough sealed envelopes handed from dying men to overlooked granddaughters to know what was probably inside. But I had given Grandpa my word, and I did not open the envelope until the day I needed it. The day I needed it was a Tuesday in March, when a lawyer I'd never met sent me a certified letter asking me to sign away a 240-acre farm for $10. I opened the envelope at my kitchen counter at 6:47 p.m. on the same Tuesday the letter arrived. Inside were 4 documents, each stapled separately, each with a certified copy stamp from the clerk of court in my grandfather's county. I recognized the stamps. I'd filed documents in that county courthouse the summer I interned for a small town probate attorney in my hometown, one of the few things I'd ever done in that town that I was proud of. The first document was a 41-page irrevocable trust instrument dated 6 weeks before Grandpa's death, titled The Howard Eldon Family Farm Trust, amended and restated. It had Grandpa Howard's signature on every page. It had Ruth Kirkland's signature as the drafting attorney. It had the signatures of 2 witnesses, both neighbors I recognized, and a notary stamp from a woman who had been the township clerk for 30 years. The second document was a 6-page pour-over will dated the same day, referencing the amended trust by name and number. The third document was a 2-page recorded memorandum of trust, stamped by the county recorder's office, with a recording number and a date and a filing fee notation. A memorandum of trust is the public document you record to put the world on notice that a trust exists and that the trust, not any individual, is the legal owner of the real property described. The memorandum does not disclose the beneficiaries. It does not disclose the terms. It discloses only the existence of the trust, the name of the trustee, and the legal description of the property held. The recorded memorandum named the trust as the owner of a parcel described in precise metes and bounds as 240 acres, Section 17, Township 4 North, Range 7 West. It named the trustee. The trustee was me. The fourth document was a 1-page letter in Grandpa's handwriting addressed to me. It said, Mara, if you're reading this, then your parents have finally tried to do the thing I always knew they would try to do. I'm sorry it took a letter to get you to open this envelope. I should have explained it better. Ruth will help you. Her number is on the back of this page. Call her when you're ready. The farm is yours. It always was. The trust protects it from the people who think they own it. You are the trustee and the sole beneficiary. Nobody can sell this land but you. Nobody can sign anything that affects this land but you. Everything else is just paper. Love, Grandpa. I read the letter 3 times. I didn't cry. I didn't scream. I didn't call anyone. I walked to my filing cabinet, pulled out a fresh manila folder, and began cataloging the 4 documents the way I'd catalog any client file at work. Date stamps photographed for the record, pages numbered, signatures cross-referenced, Recording numbers verified. I made a spreadsheet. I gave the file a name. Eldon, Howard, 2014, amended and restated trust, active. It took me 90 minutes. At 8:17 p.m., I poured a glass of wine I didn't drink, and I dialed the phone number Grandpa had written on the back of his letter. Ruth Kirkland answered on the third ring. She said, "This is Ruth." Just that. Flat, alert. A woman who had taken late phone calls before. I said, "Miss Kirkland, my name is Mara Eldon. I'm Howard Eldon's granddaughter. I'm sorry to be calling so late." There was a pause. Then she said, "Mara, Howard told me you'd call one day. He didn't know when. How are you, honey?" I told her what had happened. I told her about the letter from Bram Hollis. I told her about the quit claim deed attached. I told her that I had opened the envelope 30 minutes ago and that I had just finished indexing the 4 documents it contained. I told her I was a paralegal and that I understood what I was looking at. And I told her I needed her help to do this correctly. Ruth was quiet for a few seconds. Then she said, "Good. That's good. You understand what you have." I said, "I think I do, but I want to walk through it with you." She said, "Let's do that." Ruth walked me through the trust instrument clause by clause over the next 40 minutes. I took notes on a yellow legal pad. The trust, she said, was an irrevocable trust, which meant Grandpa Howard could not have amended it after execution, even if he'd wanted to. The funding of the trust, the transfer of the farm real estate into the trust ownership, had been completed on the same day the trust was executed by a recorded warranty deed from Grandpa Howard individually to the trust. That warranty deed was also recorded at the county recorder's office with a recording number 6 numbers later than the memorandum of trust, which meant, as a matter of public record, my grandfather had owned the farm on the morning of the execution, and the trust had owned the farm by the afternoon of the execution, every day since, for 12 years. Which meant my parents had never owned the farm. Not when Grandpa died, not at the funeral. Not 3 years later, when my father started telling people at church that the farm is in the family's hands now. Not last year, when my mother apparently told the neighbors they were thinking about what to do with Howard's acreage. Not 3 weeks ago, when they apparently signed a purchase agreement with a developer to sell a piece of property they did not own. Ruth said, "Mara, listen to me. Your parents cannot sell that land. No one can sell that land except you. And the only document they would need to sell it legally is a document you have never seen because it does not exist. Do you understand what I'm telling you?" I said, "I understand. I want to see what they filed." Ruth said, "I'll pull it tomorrow morning. I'll call you back by noon." Mara, one more thing. Your grandfather loved you. I watched him sign these documents. I watched him cry when he signed them. He told me the only thing he was afraid of was that you'd forget to open the envelope. Don't forget he loved you, honey. Not for 1 second. I thanked her. I hung up. I stood at the kitchen counter for a long time. Then I went to bed. I slept for 6 hours, which was more than I expected. I want to pause here for a second. If you've ever had a family member ask you to sign a document you didn't fully understand and your gut told you not to, and you walked away from that table without signing and without an explanation that would have made sense to them, I see you. I know what that costs. I spent 12 years being the daughter who wouldn't cooperate with my own parents, and I carried it quietly, and I didn't know until 3 weeks ago what it had actually protected. If this story is hitting close to home, go ahead and hit subscribe and tell me in the comments, have you ever trusted your gut against your family and held the line without knowing why? I want to read every one of your answers. And if you want to hear what Ruth found at the recorder's office the next morning, stay with me. This is where the paper starts to move. Ruth called me back at 10:42 the next morning. I was at my desk at work. I took the call in the small conference room we use for beneficiary meetings, and I closed the door. Ruth said, "They filed a warranty deed signed by your father and your mother as individuals, purporting to convey the full 240 acres to a limited liability company called Clearfield Ag Holdings, LLC, recorded 3 weeks ago, for a stated consideration of $2.4 million. I said, "Recorded where?" She said, "County Recorder, same office that has the memorandum and the original funding deed on file." I said, "The recorder accepted it?" She said, "The recorder took the filing fee. The recorder does not perform a title search. That's the job of the title company. And the title company hasn't issued a policy yet. I called. They've issued a preliminary commitment subject to resolution of a title exception." I said, "What exception?" Ruth said, "Let me read it to you. Exception 4B. The property described herein may be subject to an unrecorded or partially recorded interest held in trust pursuant to instruments recorded at Book 412, page 889, and Book 412, page 895. Buyer is advised that said title exception must be resolved, released, or waived prior to issuance of owner's title insurance." I said, "The memorandum of trust." She said, "The memorandum of trust." The title examiner caught it. She flagged it. She sent a letter to Bram Hollis, your parents' attorney, 3 weeks ago, asking him to produce a release from the trust. He did not produce one. He instead asked the title company for a 60-day extension and told them, quote, "We are in the process of obtaining the signatures of any potentially interested parties of record," end quote. I said, "That's me." Ruth said, "That's you." I said, "He doesn't know who the trustee is." Ruth said, "He does not." The memorandum names the trustee, but the trustee's address is given as the law firm of record, which is me, which is a P.O. box in a town he's probably never heard of. He sent the letter to you because your name is in the family tree and because your parents told him to. He has no idea you're the trustee. He has no idea there's a trust. He thinks this is a stubborn daughter who needs to sign a piece of paper. I said, "How long until the title extension runs out?" Ruth said, 37 days. I said, "And if they can't produce a release?" Ruth said, "The deal dies. The purchase agreement has a standard contingency clause. If clear title cannot be delivered by the closing date, the buyer can terminate and recover their earnest money, which I expect is 5% of the purchase price, or $120,000. Your parents have been holding that $120,000 in escrow at the title company since they signed the agreement. If the deal dies and the buyer walks, that $120,000 goes back to the buyer. Your parents don't get it. I said, and if my parents sign a false release? Ruth said, then they have committed a criminal act. A release of trust signed by someone who is not the trustee is a forged instrument. Under our state statute, that's a Class C felony, per signature. I said, how many signatures would they need? Ruth said, at minimum 2, one for the release of trust, one for a corrective deed. I said, 2 Class C felonies? Ruth said, minimum. I sat with that for a minute. Then I said, Ruth, I want to do this correctly. I want them to have every opportunity to walk away from this without going to prison. I don't want revenge. I want the farm. Ruth said, good girl. That's the right answer. Here's what I think we do. And she told me. Ruth's plan was simple and it was clean and it was going to take 12 days to execute properly. Day 1 through day 3. I would obtain certified copies of all 4 documents from the clerk of court. Ruth would draft a letter from her office on her letterhead to Bram Hollis, notifying him of the existence of the trust and enclosing a certified copy of the memorandum. Day 4 through day 6, we would wait. Bram Hollis would call my parents. My parents would tell him the memorandum was a mistake or something Grandpa signed when he wasn't thinking clearly or some other story. Bram Hollis would ask them to produce any release, amendment, or superseding instrument they had. They would not produce one because no such instrument existed. Bram Hollis would then either withdraw from the representation or he would call Ruth. Day 7. Ruth would offer on my behalf to attend a meeting at Bram Hollis's office to sign the paperwork necessary to resolve the title exception. Day 8 through day 11, we would prepare. Day 12, I would fly home. I would walk into Bram Hollis's conference room. I would bring the paperwork. Ruth said, Mara, I want to ask you something, and I need you to think before you answer. Do you want your father in that conference room? I said, yes. She said, why? I said, because I want him to hear me say it. I want him to watch me hand the paperwork across the table. I want him to sit there while I explain what Grandpa did and why. I've spent 12 years being told I don't know what I'm doing. I want him to sit in a room where I do. Ruth said, that's a good answer. I'll ask Bram to have him there. He won't say no. He'll think he's being invited to watch you sign. I said, good. Let him think that. Ruth said, Mara, your grandfather would be proud of you. I said, don't say that. Not yet. She said, all right, I'll save it. The family starts calling. Day 5. My mother called. I let it ring. She left a voicemail. Then she called again. And again. 7 calls in 90 minutes. On the 8th call, I picked up. I said, hello. She said, Mara, honey, we've been trying to reach you. There's a family situation. We need to talk. I said, go ahead. She said, your father and I are selling the farm. We got a good offer. It's time. We've been trying to reach you because there's some paperwork you need to sign. It's nothing really, just a formality. The lawyer said you're the last holdout. Your brother already signed. Your aunt already signed. Everyone already signed. We just need you to come in and sign, and then this is done. I know we haven't talked in a while, but this is family business, and I know you'll do the right thing. I noticed she said the lawyer said, not our lawyer. the lawyer, like he was a shared resource, like I was supposed to treat his instructions as neutral. I said, Mom, I got a letter from Bram Hollis 3 weeks ago. I haven't signed anything. I'm not going to sign anything. She said, Mara, don't do this. Don't be difficult. I said, I'm not being difficult. I'm telling you, I'm not signing the quitclaim deed. I'm telling you, I have questions about the documentation. I'd like to come to the signing meeting and ask them in person. She paused. Then she said, You want to come to the meeting? I said, yes. She said, why? I said, because you're my family. Because this is the farm. Because I want to understand what's happening. She was quiet for 8 seconds. I counted. Then she said, Your father won't like that. I said, I'm not asking him. She said, Mara, don't start with me. I'll tell him, but I'm warning you, if you come to this meeting to make a scene, I will not speak to you again. Do you understand me? This is a business meeting. It's not therapy. It's not a reconciliation. It's not a chance for you to air your grievances. You show up, you sign, you leave. If you can't do that, stay where you are. I said, Mom, I understand. I'll see you at the meeting. She hung up. I added the call to my timeline. I wrote, Mother, day 5. Referenced, the lawyer said. Claimed brother and aunt had already signed. Threatened no contact if I made a scene. Confirmed meeting attendance. 2 hours later, my brother Router called. His voicemail said, Mara, it's Reuter. Mom said you're being weird about the farm thing. Just sign it, okay? Don't make it a whole thing. You've already checked out of this family. Don't pretend to care now. I did not return the call. I added him to the timeline. Brother, day 5. Tried to shame me out of attending. Implied I had already forfeited status as family. Day 6, my father called. He did not leave a voicemail. He called 6 times in a row at 8:47 p.m., then 8:48, then 8:49, then 8:52, then 9:04, then 9:11. Then he sent a text. It said, Mara, meeting is the 22nd, 10 a.m., Bram Hollis's office, Liberty Street. You'll come, you'll sign, we won't ask for anything else. Your mother is upset. Don't make this worse. I wrote back, I'll be there at 10. I'll bring my attorney. He did not respond for 43 minutes. Then he wrote, Your attorney? What attorney? Mara, we've been through this. You don't need an attorney for a quit claim deed. I wrote, Her name is Ruth Kirkland. She was Grandpa's attorney. I'll see you on the 22nd. He did not respond, but I know my father. I know what happened next. He called Bram Hollis. He asked Bram if he'd ever heard of Ruth Kirkland. Bram said yes. She was an attorney in the old county, semi-retired, handled estate work. Bram asked my father if Ruth Kirkland had represented Grandpa Howard. My father said he didn't know. He said Grandpa had used some lawyer toward the end, but he'd assumed the estate had been closed. Bram said, Dalton, when was Howard's estate closed? My father did not know. Bram Hollis, who is not a bad lawyer, he's a competent small-town attorney who runs a clean practice, then did what any competent small-town attorney would do on a Thursday afternoon. He called the clerk of court in my grandfather's county, and he asked whether Howard Eldon had any testamentary instruments on file. The clerk said yes. A pour-over will, dated 12 years ago, referencing an amended and restated trust recorded at book 412. Bram Hollis, on his Thursday afternoon, went to the county recorder's online search and pulled up book 412, page 889. He read the memorandum of trust. He saw the name of the trustee. He sat at his desk for a while. Then he did what competent attorneys do when they realize they have a problem. He called Ruth Kirkland. Ruth called me that night. She said, "Mara, he called. He's not stupid. He's not in this to commit fraud. He's going to advise your parents to stand down. But your father is going to push back. He's going to insist the meeting happens. He's going to believe he can talk you out of it face to face. He thinks you're still 22. He thinks you'll fold if he uses the right tone." I said, "Good. Let him think that." Ruth said, "The meeting is on. Bram will have a court reporter and a notary there. He'll have his 2 paralegals. The buyer's broker has asked to attend because their earnest money is at risk. The title officer has asked to attend because she's the one who flagged the exception. I've confirmed I'll be there. That's 8 people in the room, plus you and your father. 10 witnesses, Mara, in a conference room on a public legal record." I said 10. Ruth said 10. "This is going to happen where everyone can see it." I said, "Good." I didn't sleep well that night, but I slept. I spent the last 3 days before the meeting doing what I do at work every week. I built a binder. Tab 1, certified copy of the amended and restated trust dated 12 years ago with signature pages. Tab 2, certified copy of the pour-over will. Tab 3, certified copy of the recorded memorandum of trust with the recording stamp visible. Tab 4, certified copy of the warranty deed from Grandpa Howard individually to the trust with the recording stamp visible. Tab 5, certified copy of the title company's preliminary commitment, including exception 4B. Tab 6, certified copy of the warranty deed my parents had recorded 3 weeks ago, purporting to convey the 240 acres from themselves, individually, to Clearfield Ag Holdings, LLC. Tab 7, a 2-page memorandum I drafted myself and Ruth reviewed, explaining the chain of title and identifying by page and paragraph every defect in my parents' recorded deed. Tab 8, a 1-page declaration signed by me and notarized, stating that as the acting sole trustee and sole beneficiary of the Howard Eldon Family Farm Trust, I had not authorized, ratified, or consented to any transfer of the 240-acre parcel described in the memorandum of trust, and that any instrument purporting to convey said parcel without my signature as trustee was, as a matter of law, void ab initio. Tab 9, a clean, unsigned notice of rejection of quit-claim deed drafted for my signature at the meeting. Tab 10, a clean, unsigned notice of revocation of unauthorized deed to be recorded at the county recorder's office within 24 hours of the meeting. I printed 3 copies of the binder, one for me, one for Ruth, one to hand to Bram Hollis at the meeting. The night before I flew out, I sat at my kitchen counter with my suitcase packed and my binder zipped in my carry-on, and I looked at my grandfather's envelope one more time. The flap was torn now. The letter was folded in my wallet. The documents had been scanned, indexed, and backed up to 2 separate secure drives. I thought about my grandfather at his kitchen table, 84 years old, drinking his black coffee, telling me not to make a scene. I wasn't going to make a scene. I was going to walk into a conference room with a binder and a pen. I want to pause one more time before I take you into that conference room. Right now, I'm standing in an airport terminal in a city 300 miles from where I grew up, with a carry-on that contains a 3-ring binder and a certified copy of a trust instrument my parents have never seen. I'm wearing a navy suit and flat heels. I've had 2 coffees. I'm not nervous. If you've ever been doubted by the people who were supposed to believe in you, if you've ever been called dramatic for having the documentation they didn't want you to have, hit that like button. This one's for you. And I want to ask you a question before we go in. Would you have walked into that conference room? Or would you have stayed 300 miles away and let your attorney handle it by mail? Drop your answer in the comments. I want to know. Now let me tell you what happened at Bram Hollis's office on the 22nd. I land at 7:45 a.m. I rent a car at the airport. I drive the 53 miles to Liberty Street in a silence I do not fill with music. I pass the high school I went to. I pass the diner where my father used to take Ryder after baseball practice. I pass the turn to my parents' street, and I do not turn. I arrive at the office building at 9:42 a.m. I park. I sit in the car for 4 minutes with the binder on my lap. I check my phone. Ruth has texted. I'm in the conference room. Bram greeted me cordially. Your father is not here yet. Title officer and buyer's broker are here. Bram is professional. Court reporter is set up. Come in when you're ready. I get out of the car. The building is one of those old Liberty Street buildings with a stone facade and an old brass plate by the door, Hollis and Partners. I've been in nicer firms, and I've been in worse. I take the elevator to the 3rd floor. The receptionist is a woman in her 50s with reading glasses on a beaded chain. She looks up when I come in. I say, Mara Eldon, I'm here for the 10 o'clock. She looks down at her book. She looks up at me. She says, they're in the main conference room. Mr. Hollis asked me to bring you back when you arrived. Can I get you water or coffee? I say, water, please. She walks me down a hallway. There are photographs on the wall. Old pictures of Liberty Street. A photograph of the first Liberty Street Bar Association banquet, black and white, 1956. She opens the door to the conference room. The room has a long walnut table. Along the far wall is a row of windows looking out onto the street. At the head of the table is a man I assume is Bram Hollis, mid-50s, khakis, blue shirt, half glasses, gray beard, neatly trimmed. To his right is a younger woman in a gray suit with a stenograph machine in front of her. To her right is another younger woman with a laptop open and a notary stamp next to her elbow. To Bram's left are 2 people I don't recognize, a woman in a navy blazer with a title company lanyard and a man in a gray sport coat with a folder open in front of him, the buyer's broker. Ruth Kirkland is seated halfway down the table on the window side. She is 72 years old. She has short white hair. She is wearing a camel-colored cardigan over a white blouse. When I come in, she stands up. She does not smile. She nods. My father is not in the room. I take the seat next to Ruth. I set my binder on the table in front of me. The receptionist brings me a glass of water. I thank her. She leaves. Bram Hollis looks at his watch. He says, your father confirmed 10 o'clock. He's running late. He'll be here. Ruth says, we'll wait. We wait for 7 minutes. The stenographer's cursor blinks. The title officer opens a file folder. The buyer's broker checks his phone. Bram Hollis makes small talk about the weather. At 10:07, the conference room door opens. My father walks in. He is wearing a tan sport coat over a blue Oxford shirt and khaki pants. He has gained weight since I last saw him. His hair is thinner. He is 68 years old. He looks at me like he is trying to figure out if I am who he thought I was. He says, "Mara," flat. I say, "Dad," flat. He sits down across the table from me, next to Bram Hollis. He does not say hello to Ruth. Bram Hollis clears his throat. He says, "All right, let the record reflect that we are meeting on the 22nd of the month in the offices of Hollis and Partners for the purpose of resolving a title exception in connection with the sale of a 240-acre parcel legally described as Section 17, Township 4 North, Range 7 West by Dalton and Linnea Eldon as sellers to Clearfield Ag Holdings, LLC, as buyer. Present are Dalton Eldon, seller, Mara Eldon, a potentially interested party of record, Ruth Kirkland, counsel for Ms. Eldon, myself, counsel for Mr. and Mrs. Eldon, Meredith Bain, title officer for Stillwater Title, Jonah Paris, buyer's broker, Claire Eastman, court reporter, and Tamsin Ford, paralegal and notary. Shall we begin? Ruth says, yes. My father says, let's just get this done. Mara, we brought the deed. Bram has it. Sign it. We can all go home and this can be over. I do not respond. Bram Hollis says, Mr. Eldon, let's let Miss Kirkland walk us through her client's position first. My father says, she doesn't have a position. She's here to sign a quit-claim deed. That's what we're here for. Ruth says, Mr. Eldon, with respect, please let counsel do their work. My father sits back in his chair. He crosses his arms. He says, Bram, can I ask my daughter a question before we get started? Bram says, Dalton, I'd prefer we go through counsel. My father says, it's a simple question. Mara, honey, why are you doing this? I do not answer. He says, is this about your mother? Is this about the party when you were 8? Is this about the loan we couldn't give you? Is this about Thanksgiving 12 years ago? Because if it is, I want you to know we're sorry. Your mother and I have talked about it. We know we weren't perfect parents. But to drag this farm sale into your whatever this is unfair. It's unfair to us. It's unfair to your brother. It's unfair to the buyer. I do not answer. He says, you've been gone 5 years. 5 years without a word. Not a Christmas card. Not a phone call. Nothing. And now you show up here with a lawyer? With what? What do you think you have, Mara? You don't know anything about this farm. You haven't set foot on it in 12 years. I've been running that land since Grandpa died. I've been paying the property tax. I've been paying the insurance. I've been the one making the decisions about the family's assets. Your mother and I made a hard decision about selling. We're in our late 60s. We're tired. We want to retire. And you, who haven't lifted a finger, want to come in here at the last minute and make it harder. For what? So you can feel important? I do not answer. He turns to Bram Hollis. He says, Bram, she's not going to say anything. She does this. She's always done this. She sits there and she won't talk and she makes everybody else do the work. Can we just put the deed in front of her and let her sign it? Bram says, Dalton, please. My father looks at me one more time. He says, Mara, last chance. sign the deed. We'll pay your travel. We'll pay your lawyer's hourly rate today. You can walk out of here with a check and go back to answering phones. Or you can sit there and waste everyone's time. Which is it? I count. 8 seconds of silence. Ruth does not speak. Bram does not speak. The court reporter keeps typing. Then I say, Dad, I'm not going to sign the quitclaim deed. My father says, why not? I say, because the quitclaim deed transfers an interest I do not have. I don't have a 1/8 interest in the farm. I don't have any interest in the farm. Neither do you. My father's face shifts, not dramatically, just a little. He says, Mara, what are you talking about? I look at Bram Hollis. I say, Mr. Hollis, may I distribute a binder to the parties at this table? I have 3 copies, one for you, one for the title officer, one for the buyer's broker. My father is welcome to look at any of them. Bram Hollis looks at Ruth. Ruth nods. Bram says, please do. I open my bag. I pull out 3 identical black 3-ring binders. I slide one across the table to Bram Hollis. I slide one to Meredith Bain at the title company. I slide one to Jonah Paris for the buyer. I keep one in front of me. I say, each binder has 10 tabs. I'm going to walk us through the first 6. Please turn to tab 1. There is a rustle of pages. My father does not move. I say tab 1 is a certified copy of a document titled the Howard Eldon Family Farm Trust, amended and restated. It was executed 12 years ago on April 14th in the offices of Ruth Kirkland. It is an irrevocable trust instrument. It is 41 pages long. It bears my grandfather's signature on every page. The trust was funded the same day by a warranty deed, which you'll find at tab 4. Please turn to tab 3 first. I wait. Everyone turns. I say, tab 3 is a recorded memorandum of trust. It is recorded at book 412, page 889, in the county recorder's office. It was recorded 12 years ago on April 16th. It is a public document. Any title examiner, realtor, or attorney who pulled the chain of title on this property in the last 12 years would have seen this memorandum. It is the reason exception 4B appears on the preliminary title commitment, which is at tab 5. I pause. I look at my father. He has not picked up the binder. I say the memorandum of trust names the trust as the owner of the real property described in metes and bounds as 240 acres, section 17, township 4 north, range 7 west. That is the same legal description as the property described in the purchase agreement between my parents and Clearfield Ag Holdings. The 2 descriptions match word for word. Meredith Bain, the title officer, nods slightly. She has the binder open. She is reading. I say tab 4 is the funding deed. A warranty deed from Howard Eldon individually to the trust. Recorded 6 days after the memorandum. This is the deed that transferred legal ownership of the 240 acres from my grandfather individually to the trust. After this deed was recorded, my grandfather no longer owned the property individually. The trust owned it. That was 12 years ago. My father says, Mara, whatever you think you have, this is not what you think it is. Grandpa was, I say, Dad, please let me finish. You'll have a chance. He closes his mouth. I say, tab 6 is a certified copy of the warranty deed that you and Mom recorded 3 weeks ago, the one purporting to convey the 240 acres from the two of you individually to Clearfield Ag Holdings. I want to point something out about this deed. Please look at the grantor block. It names Dalton Eldon and Linnea Eldon individually as grantors. It does not identify either of you as trustees of any trust. It does not reference the Howard Eldon Family Farm Trust. It purports to convey a fee simple interest that you do not own. This deed is void. As a matter of law, it conveys nothing because a grantor cannot convey what a grantor does not own. Meredith Bain looks up at Bram Hollis. I say, Tab 7 is a memorandum I drafted and that Ms. Kirkland reviewed, explaining the defects in the recorded deed paragraph by paragraph. I will not read it aloud. You can read it at your leisure. My father says, Bram, what is she talking about? Bram Hollis is looking at tab 3. He does not answer. I say tab 8 is a declaration I signed last Thursday, notarized, stating that as the acting sole trustee of the Howard Eldon Family Farm Trust, I have not authorized, ratified, or consented to any transfer of the 240-acre parcel. It states that any instrument purporting to convey that parcel without my signature as trustee is void. Ab initio. It is sworn testimony. It will be recorded at the county recorder's office within 24 hours of this meeting. I turn the page in my own binder. I say, there is one more thing I want to say, and then I'm going to let Miss Kirkland speak. The trust names me as the sole trustee. It also names me as the sole beneficiary. My grandfather executed this trust 6 weeks before his death. He executed it knowingly, willingly, and with the advice of his own counsel, who is sitting to my right. The 2 witnesses and the notary are all still alive. They are all willing to attest to the execution. The trust is irrevocable. The trust was not and cannot be amended or revoked. It was funded 12 years ago. It has been in existence for 12 years. It has been recorded in the public record for 12 years. Nobody asked me to speak about it, so I did not. But the public record has been available to anyone who wanted to look. I close my binder. I look at my father. He is very still. I say, Dad, I have spent 12 years being told I was the difficult one. I was the one who wouldn't cooperate. I was the one who walked away. I was the one who answered phones at a law place. I was not a receptionist. I was never a receptionist. I have been a paralegal for 11 years. I am a senior paralegal in the Trust Administration Department of a firm with 17 attorneys. I draft instruments like this one every week. I recognize a memorandum of trust at 100 paces. I can pull a chain of title from memory. And I knew on the Tuesday I opened your letter that you had recorded a deed that could not survive a title search. Ruth Kirkland says quietly, I was Howard Eldon's attorney. I drafted the trust. I watched him execute it. I was there when he delivered the envelope to his granddaughter 12 years ago. I have his original file. everything Ms. Eldon has said is accurate. My father opens the binder in front of him. He turns to tab 3. He reads. He turns to tab 4. He reads. He turns to tab 6. He reads the deed he signed 3 weeks ago. And he reads the deed Grandpa Howard signed 12 years ago. And he reads the gap between them, which is the gap between what he thought he owned and what he actually owned. He says, This can't be right. Grandpa he would have told me. I say, he did not tell you. That was the point. He says, he couldn't have signed this. He wasn't in his right mind in the last year. Everybody knew that. Ruth says, Dalton, your father was perfectly lucid on the day he executed this trust. He had a full mental status examination by his primary care physician 2 days before the execution. That examination is in my file. I will produce it if necessary. My father says, Bram, help me out here. There's some mistake. There's a process. There's a process for this. Bram Hollis closes his binder. He removes his half glasses. He sets them on the table. He says, Dalton, there's no process that undoes this. The trust is irrevocable. It was recorded. It predates every act of ownership you've claimed over this property since your father's death. Your daughter is the trustee and the sole beneficiary. The warranty deed you recorded 3 weeks ago is a nullity. I am going to have to withdraw from this representation because I cannot ethically continue to represent a client in a transaction I now know to be unauthorized. My father says, You're withdrawing. Bram Hollis says, Yes, effective immediately. Meredith Bain, the title officer, says, Mr. Eldon, Stillwater Title will not issue a policy on this transaction. We will be notifying Clearfield Ag Holdings this afternoon that the title exception cannot be cured. The purchase agreement will terminate by operation of the title contingency clause. Jonah Paris, the buyer's broker, says, My client is going to want the earnest money returned today, and he's going to have a conversation with me about whether he has any recourse against the sellers for costs incurred during the due diligence period. Bram Hollis says, Jonah, I expect that conversation will need to happen directly between your client's counsel and Mr. and Mrs. Eldon's new counsel, whoever that turns out to be. My father says, wait, let's slow down. Mara, honey, let's talk about this, family to family. We don't need lawyers for this. I'm sure we can. I say, Dad, we do need lawyers for this. This is not a family conversation. This is a legal proceeding that you initiated by recording a false deed and sending me a quitclaim under color of an attorney's letterhead. The lawyers are what makes this safe for everyone in the room, including you. Please stop asking me to talk to you family to family. That's not what this is. He looks at me. His eyes are wet. Not tears, something else. The look of a man realizing that the daughter he spent 34 years underestimating has spent 12 of those years learning exactly how to do what he just watched her do. He says, Mara, please. I say, Dad, I am going to offer you something, and I need you to listen carefully. I am going to allow you and Mom to sign a corrective deed that retroactively acknowledges the trust's ownership of the property. I am going to allow you to do this rather than leaving the forged deed on the public record, which would create a cloud on title that I would eventually have to clear by filing a quiet title action, which would be a matter of public record in the same county where your real estate license is issued. If you sign the corrective deed today, the public record will show that you made a mistake and corrected it. If you do not sign, the public record will show what the forensic title examination finds. I am not going to make that decision for you. Miss Kirkland has a corrective deed drafted. It is tab 9 in your binder. I suggest you take a few minutes to look at it, and then I suggest you call an attorney who is not Mr. Hollis, because Mr. Hollis has withdrawn. My father does not speak. His hands are flat on the table. They are shaking slightly, not much, but I notice. Ruth Kirkland says, "We'll give you an hour. We'll be at the diner across the street. If you'd like to sign the corrective deed today, bring it with you when we return. If not, we'll proceed with a quiet title action next week." We stand up. Ruth picks up her coat. I pick up my binder. We walk out of the conference room. The stenographer types. I do not look back at my father. We sit at a booth at the diner across the street. Ruth orders coffee and a piece of pie. I order coffee. We do not speak for the first 5 minutes. Then Ruth's phone buzzes. She looks at it. She says, "Meredith Bain just emailed me. Stillwater Title has formally rescinded the preliminary commitment. They are returning the buyer's earnest money to escrow, and they are sending a statutory notice of rescission to Clearfield Ag Holdings by end of business. The deal is dead." 2 minutes later, her phone buzzes again. She says, "The buyer's broker just emailed. Clearfield is formally withdrawing the offer. They are also, this is interesting, they are also filing a complaint with the State Real Estate Commission against your father, alleging failure to disclose a material title defect. That's a licensing matter. That will trigger an inquiry." My coffee has gone cold. I have not taken a sip. At 11:47, Ruth's phone buzzes again. It is Bram Hollis. He is calling from his desk. Ruth puts him on speaker. He says, "Ruth, your clients should be aware. Dalton signed the corrective deed. Linnea is on her way. We'll have both signatures by 12:30. I've advised them to retain separate counsel. I've also advised them to speak to a criminal attorney because my own professional responsibility rules require me to report what I've seen today if they do not self-report." Dalton understood. He is not going to fight the corrective deed. He asked me to ask you if Mara would be willing to meet with him privately before she leaves town. Ruth looks at me. I say, "No." Ruth says into the phone, "My client declines. Please have the executed corrective deed delivered to my office by 1 p.m. I'll record it at the recorder's office this afternoon. Thank you, Bram." She hangs up. She says, "Mara, you did exactly right. Every piece of it." I say, "I want to eat something. I haven't eaten today." She orders me a grilled cheese sandwich. By 4 o'clock that afternoon, 5 things have happened that I did not personally cause and did not personally control. The corrective deed has been signed, delivered, and recorded, which publicly acknowledges that my parents did not own the farm when they signed the purchase agreement 3 weeks earlier. The buyer's earnest money has been released back to Clearfield Ag Holdings. The real estate commission complaint has been filed. My father's broker's license is now under review for a potential suspension pending investigation. The notary who stamped my parents' deed, a woman who works at my father's office, has been contacted by the recorder's office. Her notary bond carrier has been notified. And the IRS has been notified, not by me, but by Ruth, because the purported sale of $2.4 million in real property triggers reporting requirements that my parents never considered, and Ruth does not believe in leaving tax exposure on the table for clients who have been quiet and correct. I am on the 6:30 flight home. My mother calls me 7 times between 4 and 9 p.m. I do not answer. She does not leave a voicemail until the 6th call. The voicemail says, "Mara, your father told me what happened. I don't know what you've done. I don't recognize you. You've destroyed this family. I hope you're happy." I listen to the voicemail once. I do not listen again. I save it to a folder on my phone called Evidence, and I do not delete it. My brother texts me at 10:47 p.m. He says, "You're a monster." I do not respond. I save the text. My aunt, my father's younger sister, a woman I had not spoken to in 8 years, calls me the next morning. Her voicemail says, "Mara, it's Aunt Faye. I just heard. I want you to know your grandfather talked to me about this before he died. He asked me to watch out for you. I didn't know how to do that. I'm sorry I didn't. If you ever want to get lunch, I'd like that. Please tell me if that's possible." I call Aunt Faye back that afternoon. We talk for 45 minutes. She tells me things about my grandmother Wren that I did not know. She tells me Grandpa Howard spent the last 6 months of his life worrying about me specifically, not about anybody else. She tells me she is proud of me. I say thank you. I tell her I'd like to visit her the next time I'm in that state. She says, "Mara, please come back to the farm sometime. It's yours. It was always going to be yours. He knew." I say, "I know." 3 months later, the corrective deed has been recorded, the quitclaim attempt has been formally withdrawn, the purchase agreement with Clearfield Ag Holdings has been unwound with no residual liability to me or the trust, and my parents are living in a condominium in a state south of their old house. They sold their primary residence to pay the retainer for the new attorney they had to hire and to settle the buyer's claim for due diligence costs. My father surrendered his real estate broker's license rather than fight the commission investigation. My mother has not spoken to me. My brother has not spoken to me either. I am told he is working for a cousin in a different industry. None of that is my problem anymore. 6 months later, I have done 3 things. First, I accepted a promotion. I am now the Director of Trust Administration at my firm. The salary bump is significant. The title was overdue. I did not ask for it. I was offered it the week I returned from the meeting by the managing partner who told me, "I've been waiting for you to claim your own authority for about 3 years. It's nice to see it happen." Second, I moved. I am living at the farm. Not all the time. I keep the city apartment because the firm is in the city and I need to be there 4 days a week. But every Friday I drive 300 miles east and I spend Friday night through Sunday night at the farmhouse my grandparents lived in for 51 years. The house needs work. The roof is going. The plumbing is from the 1970s. I have hired a contractor. He is 63 years old, and he knew my grandfather. He told me he'd waited 12 years for someone to ask him to work on that roof. Third, I have assembled what I am learning to call, without embarrassment, my chosen family. Ruth Kirkland comes out to the farm every other Sunday for lunch. She has become, at 72, the closest thing I have ever had to a mentor. Aunt Faye drives up once a month with her 2 grandchildren, who are 9 and 6. A neighbor named Adeline, a woman in her 40s who runs the next farm over, has become a genuine friend. She brings her daughter over on Saturdays. Her daughter is 7. She has started calling me Aunt Mara. I did not ask her to. She did it on her own. I did not correct her. I also have a dog now, a border collie named Wren, after my grandmother. She was a rescue. She sleeps at the foot of my bed. I have leased the 240 acres to Adeline's husband, who is a real working farmer and who needed the ground. He pays fair market rent, which funds the property taxes, the insurance, the maintenance, and a small annual distribution to a scholarship fund I established last month in my grandmother's name. The scholarship goes to young women in the county who want to study agriculture or agricultural law. The first award was given last spring. I drove out for the ceremony. I did not speak. I sat in the back. I want to tell you what I understand now that I didn't understand 12 years ago on a porch in the cold when a dying man handed me an envelope and told me not to open it until I had to. I understand that my grandfather knew exactly what my parents would try to do. He had watched my father his whole life. He knew what his son believed about paper. He knew what his son believed about daughters. He knew his son would, at some point, try to sell the land to pay for something his son thought was more important than the land. And he knew that the only thing that could stop that, the only thing that could protect the land from the people who thought they were entitled to it, was a piece of paper that my parents would not be able to talk their way around. He did not protect the land by talking to my father. He did not protect the land by appealing to my brother's sense of fairness. He did not protect the land by writing a long letter explaining how he felt. He protected the land by filing a document. That is what paper is for. I think about this a lot at the farmhouse, in the evenings, on my grandfather's porch. I think about it when I draft irrevocable trusts at work, which I now do more than ever, because I understand at the tissue level what they are actually doing. I think about it when clients ask me whether they should have a conversation with their adult children about their estate plan before they execute their documents. I tell them they can have the conversation if they want. I tell them it does not matter. Paper does the work that conversation will not do. A trust is not a feeling. A trust is not an agreement. A trust is not a conversation. A trust is a document, filed, recorded, witnessed, notarized, and entered into the public record. It protects the person who loves the land from the people who think they own it. My grandfather gave me that protection 12 years before I needed it. I kept it in a drawer. I opened it when the day came. I want to leave you with this. For 12 years, I carried an envelope I did not open because a dying man told me not to open it until I had to. I spent 5 of those years not speaking to the people who tried to take the land from me because I understood somewhere underneath the words that speaking to them would cost me more than silence would. I built a quiet professional life 300 miles from the town I grew up in. I became the thing my parents were always sure I wasn't. And when the letter came, I opened it. I read it. I counted to 8, and I reached for my grandfather's envelope instead of the phone. Setting boundaries isn't revenge. It's architecture. You build the walls before you need them. You file the documents before the fire. You give a person who loves you an envelope and you tell them, when the day comes, you'll know what this is. My grandfather understood that before I did. He built the architecture. I just had to be the person who showed up with the binder. If this story hit something for you, if you've ever been the overlooked one, the dramatic one, the one who walked out without saying a word, the one who spent years being told you were the problem when you were actually the protection, I want you to know something. The quiet you kept was not weakness. The silence you held was not defeat. Sometimes the most important thing you can do is stay composed, keep your paperwork, and wait for the day you need it. If you made it this far, thank you. I want to ask you one question. If you knew right now that someone in your family was quietly preparing to take something from you, would you talk to them about it? Or would you file the document and wait for the day the letter comes? Drop your answer in the comments. I read them. And if you want more stories like this one, check the description below. There are 3 other stories on this channel that I think you'll recognize pieces of yourself in. Subscribe to Broken Relations if you haven't already. We tell stories like this every week, and the comments section is the best part. Take care of yourselves. Keep your paperwork. I'll see you next time.